Okay, I think we're about ready to start here. If you could find a seat. We're gonna have a few more people drifting in, but we want to get underway. Welcome to our presentation. Thank you for coming to our annual presentation on the upcoming proxy season. Before we begin, I've been asked to remind you to sign the green sheets that are on your table. If you want CLE credit, you need to do that, but we also like to get everyone to sign just so we have a record of who is in attendance. I am Tim Hearn. I am a partner in the corporate department at Dorsey here in Minneapolis. Joining me today on our panel are Kimberley Anderson in the middle next to me, partner in the corporate department based in Seattle. And then we have two distinguished alumni in the local legal community, Hoang, to my immediate left, who is senior counsel and assistant secretary at General Mills, and Amy Schneider, deputy general counsel at UnitedHealth Group Incorporated. Thank you, Cam and Amy, for being here today. Unlike some proxy seasons in recent years, there were no blockbuster rule adoptions this year, which will cause you and us to scurry around creating reams of new disclosure for the proxy statement. Nevertheless, there were developments which will potentially impact you in this proxy season and which we will discuss with our panel today. Turning to the agenda slide on the screen, we will start by reviewing several developments involving directors and their compensation, election, and selection. After that are a set of topics which are relevant to the 2016 proxy season. And finally, there's a list of topics which you should be aware of, but which will not have an impact at least until the 2017 proxy season. Our plan, though, is not to cover all of these topics today.
We know you're relieved when you saw the agenda.
Yeah. You have the slide deck in your booklet there, and you can review the remainder of the slides on your own. Our aim is to get probably through the Omnicare discussion, which is halfway through the second section. We may get to voting standards, maybe proxy voting policies, but we'll stop in any case in time for any questions that people may have. So with that, I'm going to kick it off with a review and panel discussion on director compensation issues. Director compensation has been a topic of conversation in boardrooms this year because of a decision handed down in April by the Delaware Court of Chancery. The case was Calma v. Templeton, and the decision was a denial of a motion to dismiss. The case involved 8 non-employee directors of Citrix, Inc., who received awards of restricted stock units under Citrix stockholder-approved equity incentive plan. A stockholder brought claims for breach of fiduciary duty, waste, and unjust enrichment, arguing that the RSU awards, when combined with the director's cash compensation, were excessive. The defendants moved to dismiss the claims, arguing that the compensation was ratified by the stockholders through their approval of the company's equity plan. The starting point in this analysis is that the business judgment rule protects boards in decisions like this one, except that the business judgment rule does not apply if the directors have an interest in the decision for which coverage is sought. In this case, the directors were voting on their own compensation, so the business judgment rule did not apply. They were clearly interested. And instead, the entire fairness standard would apply unless the stockholders ratified the board decision in question. That was the argument that Citrix made, was that these grants of RSUs had been ratified by the stockholders by virtue of the stockholders' approval of the stock plan. This is a position which most practitioners assumed would prevail, as that's what we've relied on for years. And if it didn't, then a lot of questions would be raised about how director compensation has traditionally been determined at public companies. Guess what? The court held that ratification did not occur in this case because the stockholders were never asked to approve, quote, any action bearing specifically on the magnitude of the compensation for the company's non-employee directors. In his argument, the plaintiff noted there was a limit placed on the level of compensation that could be paid to any person under the plan, but said this limit was so high, it's the 162M limits, which are usually set incredibly high, that it was not a meaningful limit on compensation. And that terminology, meaningful limit, has come to be the hallmark of this case, and it gets repeated in all the analyses. What does a meaningful limit mean? In any case, the motion to dismiss was denied. The case is continued using the entire fairness standard as the basis for review of the director's compensation decisions. So that sets the stage for the director compensation discussion. I'm now going to ask our panel, Cam, Amy, what has been the reaction at your companies? Is this a topic in the boardroom?
Well, Tim, it's definitely been a topic that management has been discussing. And so to your point about meaningful limit, what is that? I don't think that the line of cases that we've seen have really given a lot of guidance as to that. But nevertheless, when we ask shareholders to approve our next director compensation plan, we are thinking about adding an additional limit. And so, some of the forms we're thinking about would be, could it be an amount-based limit? So a limit on total compensation that's based on some grant date fair value of the stock award. Another idea we've talked about is having a limit on the number of shares that directors are granted annually. That's a little more volatile because obviously the value of our stock will fluctuate. Practically, I'm not sure that we're concerned about the particulars of the limit so much as we want to make sure that we have the process in place to review director compensation periodically, benchmark it, and make sure that it's within bounds compared to our peers. We look at the companies that have received these lawsuits and that are getting negative attention, and frankly, their director compensation is excessive in comparison to their peers, and so we don't want to be there.
Okay.
At United, we have an omnibus plan which covers, grants for both executives and directors. And there is not currently a limit. There we go. Oh, I hear myself. Not currently a limit in there for director grants. We've had the discussion of whether or not we should, go out for an amendment on the plan specifically for that issue and determine not to do that at this time. We just amended our plan last year where we got more shares. So it won't be a while before we're up for where we need to get shareholder approval again. But we did raise this question and discussed it with our comp consultants and determined not to do anything at this time.
Has there been any discussion? I've been practicing long enough that I remember when formula plans were the standard. Everyone had a formula plan for the directors, and I believe, if my memory is correct, that was driven by a Section 16 concern. It was the standard way to get the grants to directors exempted from Section 16 coverage. Has there been any discussion of going back that far, formula-type grants, of having it hardwired into the plan of whatever, 5,000 RSUs each year or something like that?
Yes, Tim, I think that's definitely one of the considerations,
Okay.
one of our options.
Okay.
Yeah, we didn't discuss the details at all, just the concept of a cap being added at some point, but only when we're looking at other amendments at the same time.
Yeah, and just to be clear, when I mean formula plan, it's not a cap. It's here's how much they get, and it's fixed in the plan. You'll have to get shareholder approval to change the number of shares.
Yeah, I can't imagine an appetite for that.
Right. I think that's a little overreaction now. We'll see where the case law goes. It could be if this chain of cases continues that something could happen there.
Well, one of my clients they have a formula plan. They have no desire to change it. It's been in place for a while. With respect to that one, it's a dollar amount. So they get, it's like $150,000 or $200,000 per year. So it's a dollar threshold, and then it's simply a matter of, based on the formula, how many shares that you get. But it's a very defined limit, and they haven't looked to change either that dollar threshold or that plan in some time. It seems to work pretty well for them, and this case, I think, confirms that I doubt that they would move away from it now.
Right.
But we have some clients that really, really like having discretion. The board wants a lot of discretion in terms of how it structures its own comp, what they want to do. Do they want to go options, RSUs, what they want to do. And so I think it's now going to be more of a risk assessment, your desire for discretion, your desire for flexibility versus, is someone going to bring a potential action against you. So I think it's just one more piece to measure, to balance against what the board wants. So.
Good. Why don't we move ahead here to the next topic, which is proxy access, and Kimberly's going to take the lead.
I'm going to try to make this short because I'm guessing everybody has heard this about 57 times at this point. But just as a very, very broad-based refresher, is that proxy access, effectively what it does is it permits shareholder-nominated directors to be included in the proxy with management nominees. That's what it is in a nutshell. And it was the major topic last year when the New York Comptroller decided to send out their 75 letters. One of their goals was to change the conversation about proxy access, and they certainly did that. I think there's full expectation they'll be sending out, that they'll be continuing those activities. So it does continue to be a major topic for boards in different surveys. It is one of the most widely discussed governance issues in boardrooms. So, and certain people like, Vanguard, who typically is well known for supporting proxy access at about 5%, they will vote for 3%. They have done on a number of occasions, and they're very supportive of proxy access. And in fact, they, as you see from the quote, they actually, talk to different recipients of proxy access and urge them to adopt it. So when you look at the chart on the next page, you can see that the number of proposals are increasing, the pass rate is increasing, the average percentage of votes in favor is also increasing. That, that trend is just, been very, very clear and is continuing. So this topic isn't going anywhere. Increasingly, one of our clients last year got a proposal. Their first thing to do was they were convinced that this was, our institutions won't support this. Picked up the phone, called all of their clients and their institutional investors, and they all said, no, 2 thumbs up, we're going to vote for it. So at that point, they decided to revisit it and go with a dueling proposal, and they won. But their shareholders really almost, to a man, were in support of proxy access. So whether or not we ever think it's going to be used. So let me, before we bring Cam and Amy into this conversation, just going to go through some of the very sort of the common provisions. So the one that's, you can forget Whole Foods and so on with their 9% last year, which they eventually got rid of. But the most common provisions that are developing are 3% shareholder limit, ownership of 3 years, group size, if there is going to be a group limitation to meet those ownership requirements, is generally about 20. Activists hate that, by the way. The number of shareholder nominated for candidates is typically 20% or at least 2. And, there's a number of other, points of consideration. How long do shares have to be owned? Do loan shares count as owned for that ownership calculation? What percentage of candidates, is there limits or disclosure requirements when it comes to compensation if you're going to be if you are as a candidate compensated by a third party? So on these, the devil really is in the details. Sometime this month, ISS is intending to put out an FAQ regarding what it thinks are problematic proxy access provisions, what it thinks is restrictive. So I'm crossing my fingers and hoping that it doesn't tie to, CII, because I really don't like their limits. I think they're far too broad, but I think that may change the conversation a bit. But Amy, has your board been talking about proxy access?
Yeah, they've been really focused on this, pretty much since the 2015 proxy season. And they've gotten deeper and deeper in the issues as time's gone on. If you go back to our June meeting, there was just a general shareholder activism presentation, and proxy access was just a subcategory discussed in that, more at a high level. And then, of course, that the board's very interested in that, asked for more. So at the August meeting, we did a fulsome presentation where we, walked through in detail, which companies had received shareholder proposals, which ones were had management proposals, how the voting results came out. A lot of information was given to the board. We took them down the different decision alternatives, whether you want to just ignore it, do nothing, voluntarily adopt it, wait for a shareholder proposal, the strategy there and the considerations, and walk them through all of that. And then just talked about like our biggest investors, like what their opinions were on it. And then they requested, yeah, come back at the next meeting and tell us more, tell us how this, evolved. So then at our last meeting, the November meeting, we gave more specific information regarding, the voting patterns of our top 25 investors and where they're coming out on this. We have had conversations with our investors on where they are on the particular terms, if they're willing to be flexible and whatnot. And going back when we go back to them at the February meeting, we're going to bring like a draft bylaw for them to review and just for their consideration and discussion. So we haven't determined what we're going to do at this point, but our deadline for shareholder proposals is December 24th. So obviously there's a good chance we could get one, but that will impact probably what our plan is as well.
Yeah, so like Amy, I've been spending a lot of time on proxy access lately because our board is definitely focused on it. I think like a lot of companies, the question for us has moved beyond will we or won't we adopt proxy access to is it now versus later? And so are there advantages to adopting a form of proxy access either before you get a proposal or before you take a vote on a shareholder proposal? And I got to tell you, just taking it off the table as a distraction for the board of directors and allowing them to focus on their work of improving the business, it's really tempting. A couple of other potential benefits we would see would be having a little more flexibility in the terms by getting a jump ahead of the proposal. And so in particular, I think one of the most hotly contested terms has been this shareholder aggregation limit. Do you allow an unlimited number of shareholders to aggregate their shares to bring a proxy access candidate, or is it limited to 20? And so there may be some advantage of getting ahead of that. And of course, I think, Kimberley, you're going to speak to this later. If we adopt a form of proxy access now, does it give us an argument for substantial implementation later? So we'll see about that. Some of the obvious drawbacks would be, the landscape is still evolving quite rapidly, so we may not, we may be coming back to the board with an amendment to the proxy access bylaw if we adopt now. And we aren't necessarily precluding a shareholder proposal. It's going to be a very active season, I think.
So we thought it would be useful to talk about, while we're talking about proxy access, the concept of excluding them, what the options are. And so we thought we'd just sort of run through some of the different scenarios that you would most likely see. So let's say, you're like Cam, and Cam says, we're going to hold off. We're going to wait to see if we get something. So you wait, and so what happens is you don't have a proxy access, and then you receive a proposal and decide to put up a dueling management proposal. The question is, could it be excludable? The SEC has now come out. They now have slab 14H. After sitting on the sidelines most of last year, pretty much all last year, they decided to actually put out their guidelines. So it will not be it used to be last year, like Whole Foods did it, where they got a proposal, they put up their own egregious proposal, and the SEC said, yeah, they directly conflict. The SEC has now revisited that, and they've said, no, it's like, we're not going to prevent a dueling proposal. So if you haven't implemented it and get one, you're really going to be, you will have, if you want to put your own up, you will have a dueling proposal situation. So if you have implemented it, now it depends on what you get. So let's say Cam says she wants to take the distraction off the table. So they decide to adopt, and then they get a proposal. It's a very similar proposal. So let's say you get one that has a group limit of 20. You get a proposal that doesn't contain a group limit. But what it is it really is a full proxy access. We think you should adopt proxy access with this form. Well, it is possible, never a guarantee, because we don't know, the evolving mindset at the SEC is, at the moment, is still a little in flux. They're a little opaque at the moment. But last spring, they allowed GE to exclude a proposal on the basis that it was substantially implemented. GE already had a proposal. They already had a provision in place. Really, the only difference here was that, someone proposed a new proxy access proposal that had a group limit. The SEC said, you know what, good enough. Substantially implemented, you can actually omit it. So, but here is the new thing. It's a second wave of proxy access that's being proposed. And some of these proposals have been out. So let's say you're GE. The proposal would now be, we want you to modify your currently existing provision to remove the 20-person limit. It's not a brand-new provision of, gee, we want it to look like X. It's specifically stating, remove it. So in a speech this fall, the Director of Corporate Finance, Corporation Finance, Keith Higgins, when talking about this kind of second wave, said, well, you know, I don't really think that you might not be able to take this out as substantially implemented because there really isn't something that's been substantially implemented. It's, you know, they are specifically saying, remove this. So I think, you know, and we haven't really seen the SEC come down officially on this one, but I think that's where the next battleground is going to be, is how you respond to that proxy access proposal, as opposed to the general one, which is a little more, that path is a little more well-worn. But the second wave, the fixing of proxy light, as they describe it, is, I think, going to be accelerating this year. So we'll see how that comes out.
And, I mean, I gotta say, just given the SEC's position on conflicting proposals, I don't like companies' chances of getting a generous interpretation of substantial implementations.
Yeah. They seem to be cracking down. They're being much more conservative about what they're willing to exclude. So
Yeah.
I agree with you. I think that one's going to be very difficult to exclude.
And that was our experience last year. We had received a proposal from John Chevedden to adopt a policy requiring that we have an independent board chair. And we already have an independent board chair, and our policy says we should have one. So we tried to argue that we could exclude the proposal from our proxy statement because we already had what they were requesting, but the SEC disagreed, and it was because it wasn't required, and we said we should have it, that it wasn't substantially implemented, and it went in our proxy statement, so.
So the difference
So it's a
between
tough battle.
should versus shall is what did you end up?
Yeah.
So-
And I mean, what else do you want us to do? But yeah, from a practical standpoint, we had everything in place that he wanted from a governance standpoint, but our document says we should have it instead of shall.
Yeah, just doesn't make sense.
Yeah, it's a little silly, but.
So, universal proxy ballots. We're going to talk about this for about 1 minute, mostly so because I think most people really don't think about it, and most people don't have to. Right now, when you think about a proxy ballot, you know, if you want to vote for the management slate, you tick off what you want. If for some reason you decide, then you then get a ballot from an activist that has a different slate, and you're like, oh, well, I like Bob, but I don't like Jim. And so you want to vote on both ballots. You can't do it because the later dated proxy will supersede. So you can't mix and match with two proxies. So you would actually have to physically show up at the meeting and vote. And so the SEC is saying, you know, does it really make sense that we would force shareholder, you know, that we're not going to permit shareholders to do something by proxy that they're actually able to do in person? So the SEC is actually looking at this. Chair White has requested rulemaking. At some point, I expect, given the trend at the SEC, it wouldn't surprise me if this goes in place. And I think that could be very, very helpful for activists. But, so we expect at some point that will come down. But the SEC's rulemaking list is, you know, keeps getting longer. So I'm not sure where this one fits. I'm kind of hoping it's somewhere near the bottom, but it's, you know, their internal agenda is their business. So, but anyways, we just wanted to let you know, so in case anyone, you're thinking about it, that's the reason for a universal proxy ballot, and that's what it does.
Yeah. And I might say, you know, if you connect the dots between universal proxy ballots, proxy access, dueling shareholder proposals, I mean, you're seeing a message from shareholders to say, if we need to, we're going to exert greater influence and control over the company proxy statement, right?
Yes,
So
and what
companies-
shareholders can propose, and their voice and what they want the shareholders to vote on.
Right.
Yeah,
So companies convince us that we don't need to do that.
yeah. And now, I think we're back over to you, Tim.
Yep. We're going to go into board composition. This is another major topic this year and actually in prior years as well, is the composition of the board. Just citing to PwC's 2015 Annual Corporate Directors Survey, for instance, it cites this year that 40% of directors think someone on their board needs to be replaced. The most often cited reasons are diminished performance due to age, a lack of preparedness, or a lack of expertise. The survey also noted that 95% of directors can view diversity as at least a somewhat important director attribute. think the only comfort we take from that, I think, is at least it's at 95%. Would
Yeah,
hope for a stronger statement.
Well, there was, and I didn't put all the details, there's some kind of amusing tidbits in this survey in case you decide you want to look at it. But there was, I think, about 45% said it was very important. And then, by the time you get down to, it added up to 95% once you get down to the somewhat. But there was a very significant group that felt it was much more important than somewhat. So I didn't want it to, the way it's phrased is a little misleading. So I didn't want you to think badly of most directors.
So, Cam, what is your board saying about composition, or what are the conversations these days?
Well, it's definitely a more frequent conversation these days, and in fact, I'd say we recently adopted kind of an annual cycle for considering, board composition, director qualifications, evaluating our directors, and then leading up to the actual nomination and the election at the annual meeting. And so, this is just part of our acknowledgement that shareholders are very much interested in the independence of our board, the qualification of our directors, and making sure that we as a company and our board have the proper director succession planning in place. I'll tell you one thing, or a series of issues we have wrung our hands on is, so we do have all of this going on at the board level, so how much do we disclose in our proxy statement? Our mainstream institutional investors are interested in this, and we want them to know, and we want to communicate that we are on this. But we also have activists who periodically come in and out of our stock. And so we're concerned about the negative spaces. We're concerned that if we put up a director skills matrix in our proxy, if I was an activist, where are the weaknesses? Where are the gaps? If I, as company counsel, describe our process for considering director candidates and developing them, am I giving the activists too much of a roadmap to insert their own candidates? So I do think that there is a fine balance there between assuring your mainstream investors, but not giving away too much if your company is in an activist environment.
So, but Amy, what did you guys, because I think you put in a skills matrix. Is that it?
Well, we did 2 changes to our proxy statement last year. One, just because director tenure was such a hot topic, we added a table where we included ranges of years with the company and said how many directors fell into each range. It was like, under 5 years, 5 to 10, and then over 10 years. So we did that just to hit on the topic that we knew was of interest to a lot of investors. We also included a chart that set forth our skills matrix. We've always disclosed narratively in each bio, which skills each individual director had. But this past year, we had a big table, and they got like a check mark in each category. So that was new for us, and it was good because from a process standpoint, when that went in front of the board, then it makes them reflect more on if this is really, true, should this be updated, are the categories right, so our skills matrix we've had, it hasn't been in the proxy, but we've had it since 2008, and just at our last November meeting, the board, was taking a hard look at the different categories represented, see if they need to be updated for how our business has evolved, and seeing who's in the categories, and so really spending some, time on it, and no changes have been made. We're revisiting at the next meeting, but yeah, it's something that's, they're paying attention to and are making a priority. And we also, at the meeting in June, they considered whether or not we wanted to adopt any term limits or mandatory retirement age policies. So that was something that the governance committee considered, and we put together benchmarking data, and which was actually really interesting for me. I was surprised because I assumed all these things were just wonderful and that ISS loved them and that all investors loved them and everyone had them. So I was surprised for the term limits to see how few of the companies that we were benchmarking had them. We always look at the Fortune 25, and only 2 companies of the 24 that we looked at had term limits. But the mandatory retirement age was much more common. I think it was like 22 of those companies had them. So we took a look at whether or not that was something we wanted to have and looked at the policies for ISS and Glass Lewis. ISS, if you're talking about director tenure, they want your average board tenure to be less than 15 years, which ours was just under. And then for the ISS Quick Score, if you've served for more than 9 years, that can have a negative impact on your score.
That's one factor, but it is
Yeah,
a
it's one factor, yeah.
right.
But Glass-Lewis is not in favor of term limits. And then both ISS and Glass-Lewis are not in favor of a mandatory retirement age. So that to me was interesting because I assumed it was stuff that they were on board with and were advocating for.
Right, but if you do have term limits, Glass-Lewis is very clear that if you have term limits or age limits, they expect that you're gonna follow them. And if you decide not to follow them, you have to, really put in some real and substantial disclosure to explain why. Why did this person get a waiver? Was there something about it that caused, you to have the need, as opposed to, yeah, we just like using Bill's ski house, and we just, we can't if he's not on the board. So they want to see actual extensive, they want to see the reason, and they want that actually disclosed.
And it's funny that companies don't necessarily do that on their own, because when we were doing the benchmarking research and I would see a policy and then see somebody on the board that's over that age, and then there was no discussion about it, it's like, made me pause, but yeah, so I mean, then Glass-Lewis will not like it if you have a policy and you're not following it. And I think then their reaction is to vote against the chair of the governance committee, I think. So.
Just, I'm sorry, Cam, did you have? Just to round out the tenure topic, one interesting development is that CalPERS is weighing into this and is considering revisions to its global governance principles that would require or would say that director independence can be compromised at 10 years of service. So trying to set up a 10-year maximum approach. Now that's CalPERS, as the panelists have said. ISS and Glass-Lewis have taken a much more of a hands-off or laissez-faire approach to this and have not tried to dictate. So we'll see where this goes.
Yeah, I mean, I think the concept is that it's not, one size fits all. And in theory, I mean, if you have a good evaluation process in place, you don't need this. So,
Right.
That's kind of what they fall back on. As long as you're getting rid of people that aren't performing through the evaluation process, you don't need to have these arbitrary limits.
And, I mean, it's always enlightening for me to sit down and talk to colleagues like Amy, because I can guarantee you that the directors on my board are talking to directors on her board or other boards, either in the peer space or locally. And so I think that's where, colleagues or outside counsel can be really handy in helping me to benchmark, what other boards are doing.
All right, we're going to move into the next section of the presentation. This is preparing for this proxy season. Shareholder proposal exclusions, and Kimberley is going to take the lead.
I found this interesting, but I think it's only because what I do for a living. And it also impacted me significantly last year because I had, I think, 5 letters in front of the SEC, all based on the directly conflicts, and they were beautiful letters. They should all have we should have gotten all of our shareholder proposals kicked. As it was, the SEC decided to sit on the sidelines last year. So I'm going to very, very briefly go through this, partly because I'm already behind on Tim's schedule. I'm always behind on Tim's schedule. So I'm going to try to catch up a little here. We've already discussed 14.8I10, which is the substantially implemented. That, I think, is going to be the next battleground when it comes to proxy access. So we're not really going to touch that here because we already touched on the interesting part of that one. But so there were 2 exclusions that were in the news last year. So one was the ordinary business operations. Remember the Walmart case with, they wanted to have the semi-automatic weapons eliminated. So they did this through a social policy proposal, and then the directly conflicts. So in the Trinity and Walmart case with respect to the ordinary business operations, there's a quick summary of the case. But ultimately, Trinity submitted a shareholder proposal. They wanted a board policy to seek the sale of, to review the sale of dangerous weapons, dangerous products, sorry. They specifically noted weapons. So, Walmart tries to get it out, the SEC grants a no action letter, litigation commenced, it went a couple different ways. Ultimately, the Third Circuit permitted Walmart to omit the proposal. And then it said, we think this would be an excellent time for the SEC to weigh in and clarify its guidance. And in case you're curious, at one point, Trinity decided to appeal that to the Supreme Court, but withdrew it when the SEC later issued their guidance. So on the next one, which is directly conflicts, this is Whole Foods. So this was in 2014. The SEC gave Whole Foods some no action relief when they wanted to exclude a shareholder proxy access proposal in favor of a management proposal with much higher thresholds. And so that's what led to the brouhaha, led to the SEC in January saying, we're not gonna take a position on no action requests under that rule. And I have to say, that really chapped me. But nonetheless, we move forward. So then, in October, the SEC decides to weigh in, fortunately before the proxy season really commences. On directly conflicts, which is really where the big news is, this has been substantially cut back. This is much, much narrower. It directly conflicts only if a shareholder could not logically vote in favor of both. For example, shareholder says, vote against the merger. The company says, vote for the merger. You really can't do both. So, well, you can, but essentially you've now just, it's when my husband and I vote on taxes, he votes against it, I vote for it, and then we sort of cancel each other out. That's effectively what you're doing here with one person. But shareholder proxy access proposals would not be considered excludable. So it's substantially narrower than it was just the prior season. So that was the big news. The other one on the ordinary business operations exclusion, the SEC essentially said they thought they said, we agree with the final decision of the Third Circuit. We think their analysis was wrong. And we're going to continue to apply it the way we always applied it, but really didn't give any additional guidance. So it was kind of like they thumbed their nose at the Third Circuit. But ultimately, what it comes down to is proposals that focus on a significant policy issue. They have to focus on a significant policy issue, even if they also touch on ordinary business, and that's really the only way to get them excluded. So if it talks about your ordinary business, but they're not dealing with significant policy issue, you're not going to be able to get it out. So that's when Amy, because like we said with Amy and the should versus shall, they're really getting very, very conservative on what they're going to let people cut out.
The next topic is audit committee disclosure. Although rule-driven changes are not in place for the 2016 proxy season in this area, there's been a lot of discussion about audit committee disclosure, and it's been coming from several sources. Probably the principal one was a July concept release put out by the SEC seeking public comment on expanded disclosure regarding audit committees. The focus of it was on the relationship between audit committees and the auditor, but it also called for comment on the roles and responsibilities of the committee, committee qualifications, oversight of financial reporting, internal controls, et cetera. So that has sparked a lot of conversation, but it is just a concept release, and we're a long way from rules, if any, resulting from that release. But there's also been the PCAOB is rumored or known to be considering initiatives in the audit committee disclosure area. Also, institutional investors and funds have been seeking additional information in this area. The United Brotherhood of Carpenters sent a letter to 91 Fortune 500 companies last season asking for expanded disclosure. The EY Center for Board Matters reviewed the disclosure of the Fortune 100 and found that there had been significantly increased information available in audit committees disclosed by those companies. So there's a lot of activity. And finally, going back to the PwC 2015 Annual Corporate Directors Survey, it found that approximately 10% of audit committees are currently considering expanded disclosure, and a third of the companies have already expanded disclosure beyond what's required. So it's getting a lot of attention, and I'm curious, and I'll throw it to Amy first, I guess. In terms of audit committee disclosure, have you seen any changes lately or in the last few years?
Yeah, I mean, for us, this has been going on now for a couple of years. We did receive the letter from the Carpenters Union requesting additional disclosure. And we also, on our nominating committee, have a director that's really involved in the NACD, and she's also on the audit committee, and they put out a call to action where they were saying all the additional disclosures that companies should include in their proxy statement regarding their auditors and their audit committees. So we put that in front of the board, in February of 2014, where we benchmarked the additional disclosures that were requested by the Carpenters Union and in this call to action white paper document, and compared them against, the Fortune 25 companies and against our disclosure, and saw areas where we could, add this additional disclosure that's not particularly helpful and is covered elsewhere in the document or in our charter or somewhere else, and, try to show that we're being responsive and trying to increase transparency or at least increase the disclosure. So we did that in, we added additional disclosure in our 2014 proxy statement. And, then the Carpenters appreciated that. And then for that concept release, we did submit our comments to the SEC on that, where we, basically said we don't think we need additional rules on this. We like the flexibility of the current rules, and as you can see, companies are disclosing well above and beyond what's actually required anyways, and then we recited out all the additional things that we've added over the years that's not required by any of the rules, so that, additional rulemaking wasn't really necessary.
You had a slightly different experience, didn't you?
Well, I gotta tell you, I wholeheartedly endorse Amy's skepticism about the ultimate value of this additional disclosure. And by the way, isn't the SEC supposed to be streamlining disclosure? What's going on here? Yeah, mine is probably more of a cautionary tale. So we did expand our disclosure in a few ways. We put in the auditor tenure and more detail on how we evaluate them, and so, it just goes to show, just because investors ask for disclosure doesn't mean they're going to like what you provide to them. We get our voting results back, and we're going through them with our proxy solicitor, and it turns out, it didn't make a huge impact in the vote, but there were definitely some European funds who, didn't like that our auditor had been around for 80-plus years, and the fact that we don't really have what I would consider to be a very developed auditor rotation plan. So, hello, this is America. We're supposed to pay attention to what our European investors want to. Imagine that. So I would just say if you, do have a significant European investor base, or, if you care about what they think, they may not be happy with the expanded disclosure.
Great. I think we'll move to the next topic, and this is the Omnicare case. Kimberley?
So, despite the fact that you will note that there's a lot of references in here to Section 11 and registration statements, this does matter because your annual reports and your documents are actually incorporated into your registration statement. So ultimately, what you say in your 10K and your proxy actually matter. So the question here was, when does a statement of belief, when do you get protection of something being a belief as opposed to something being an incorrect fact? Because you can have liability for a registration that contains either an untrue statement of material fact or omits to state material fact required to be stated or necessary to make statements not misleading. So, and keep in mind, these are real considerations. I know companies always struggle with this. I remember one time I had a conversation with the CEO at a company, and I said, well, he just told me that there was a terrible development. And I said, well, we're going to have to, consider that because they were in the midst of putting in the 8K. And I said, well, we're going to need to, put in some disclosure. He says, well, it's like, we don't want to put that disclosure in there because the shareholders are not going to like it. So we had to explain to him that, sometimes when the shareholders are going to hate something is when you really need to put it in. So, so what really comes down to is, and then I also have some clients who, it's going to make it sound like my clients are wonderful. They're great people. They really are. But, they struggle with how to, convey messages, et cetera. So we had to explain. I think one of the directors wanted to put something in, and they said, well, we'll just put a belief statement in front of it. We'll just say, I believe. And, we had to go through the concept of, okay, belief statements are great, but there are limits on belief statements. And the primary limit on a belief statement is you actually have to believe it. And it has to be a sincere statement of pure opinion. That's the way the Supreme Court described it. So just throwing I believe in front of something does not give you license to lie. And I know none of you ever do. I understand that. But I just want to make sure that we're clear. Now, keep in mind that an opinion, so It's not an untrue fact if you honestly believe the statement at the time it was made, even if it turns out later that it was incorrect. But keep in mind that it can still be, a belief statement can still be an untrue statement if it contains embedded facts that are wrong. So in fact, this was a quote from the opinion. I believe our TVs have the highest resolution available because we use a patented technology to which our competitors do not have access. Well, I sincerely hope you have patented technology if that is the case, because there is, there's an embedded fact in there. So, and the other one is the omits to state a material fact, because there's two parts of the test. One, what you put in there has to be true, and you can't actually omit the stuff, the omission if that is in and of itself is material. Now, really what it comes down to is for an opinion, the context and the surrounding language are relevant. You can assume that an investor, understands customs and practice of the relevant industry, so you don't need to recite every single fact known to man to be able to back up an opinion. But you also can't leave out the things that would allow an investor to understand that it's a belief statement, but it's a little iffy. So context is relevant. So what it really comes down to is when you're drafting, try to figure out what your belief statements are versus a forward-looking statement. Like, Cam and I were discussing this earlier. I do work with a lot of mining companies. If you're going to say, we anticipate that the mine will be in operation, in the third quarter, that is a forward-looking statement. We anticipate it's a schedule. That's what it's based on. Presumably, you actually have a reason for that anticipated schedule, as opposed to, I believe we have the highest resolution. So go through, try to identify what are forward-looking statements, because they have different protections, such as, the forward-looking statements need to be identified with cautionary language. And if you're coming up with true belief statements, figure out, is there enough fact here that someone can actually judge the relevance and the likelihood that this belief statement is true? So is the basis for the opinion in there? Can it be understood? Or is it a very, very tentative opinion? Then you should be putting that in there too. So when you're going through, this is just a matter of when you're drafting, keep that in mind, so that, especially when you're dealing with belief statements, to actually press them on the nature, the firmness of the belief, the pure heart. So that's just something that I think you should, just keep in mind, and I think that's it.
Well, it is the holidays, Kimberly, and I keep telling my children they have to believe to receive, and I hope I'm not, subjecting them to some additional liability. I don't know what their pure heart is.
I'm not sure that any child has a pure heart. So.
My goodness.
I have a 17-year-old, so my belief is occasionally tested. So, and I think, Tim, I think this one is now you.
Yes, voting standard disclosure. This will be quick. This is really a trap for the unwary note. This has gotten some attention this year. CII has submitted a rulemaking petition in June of this year, echoing a petition that was submitted in 2011 by the United Brotherhood of Carpenters, but just requesting staff guidance regarding disclosure of voting requirements for items on the ballot and presentation of voting options on proxy cards. And what we've taken away from this is you need to read the quote, boilerplate in your proxy statement, particularly the vote required statements, the broker non-vote treatment, the treatment of abstentions, that language. I can tell you that it's somewhat of a different experience for the people up at the panel here. I mean, Kimberley and I see a mix of proxy statements from various companies, and we don't really have a lot of control over them, so changes get made that we don't know have been made. And I am continually, my second time through a proxy statement, discovering that someone has changed for instance, the wording of the vote required statement, thinking they're creating a plain English change that just makes it work better. They will change the language so that it says that what is required is an affirmative vote by a majority of shares entitled to vote on the matter, deleting the words present and entitled to vote, thinking that's just lawyers throwing in extra words. When you make that change, you change the standard from a majority of the votes cast at the meeting to a majority of the outstanding stock, and that is a much harder standard to meet. And that is a change. I've found that multiple times in proxy statements when I'm reviewing them, that little change has been made. So you have to keep your brain turned on and read the language. Now for Cam and Amy, they of course are working with one company's proxy statement several years in a row, year after year, and they can get comfortable with the language. Although even for you guys, I assume you're reading that language just in case.
I read it.
I read it and I have nightmares about doing something like that and getting fired. It's totally important.
Yeah.
I do have to say that when we were reviewing this with, in our call yesterday to talk about the slides, both Amy and Cam said, you know, the real point here is when you get to those sections, you need to give them to your outside counsel to review. So I thought that was very good advice. And I just,
We actually said that.
Oh, and there's one more, because we actually had this experience last year, is that we were all comfortable with the ballot. It was a work of art. It was lovely. But then, Broadridge was taking the ballot and they made their own format. And what happened was some of the columns, so in other words, the ballot didn't match what Broadridge was actually sending out. So we actually had different categories. And the person who was dealing with Broadridge internally hadn't she didn't have anyone else review it, and she just missed it. So there were actually different columns in terms of, for and withhold, and one had like for, against, and abstain. And so, people were actually voting differently depending on how they received and how they accessed the ballot. So she didn't sleep for a while, but fortunately, there were enough votes that came in favor that no matter how you did it, things still passed. And so I think that was the only thing that allowed her to sleep afterwards. But it's sort of one more thing to check.
Yeah, I've actually had that experience with Broadridge where I have to argue to get my wording in there because they say it doesn't fit or whatever. Yeah. And it's like, well, it needs to be that way. Yeah. So they figured it out every time. But yeah, they're very much so want to just go back to like their easy format and that the boxes need to be here, whatever, so. Yeah.
I think we'll wrap up with the last topic, the ISS or the proxy guidelines, proxy voting guidelines, ISS and Glass-Lewis. And Kimberly, I think you have about 2 minutes.
Well, that's good because there isn't a whole lot here, at least for this year. So I'm just going to hit the high points, which for both of them is on director overboarding. So 2016 is really a transition year. But in 2017, ISS for directors, or outside directors, if you serve on more than 5 public company boards, that is what they will be considered to be overboarded. This year, it is still 6. But this year, they will be issuing cautionary language to kind of give you a heads up, like, oh, hey, this guy next year, we will consider to be overboarded. For CEOs, they did not change the limit. So for a CEO, you can serve on your own board plus 2 others. For Glass-Lewis, there are some other, actually, ISS made one other change we'll touch on briefly. With respect to unilateral board actions, such that, like, if you decide to implement a classified board, supermajority voting, et cetera, without taking it to your shareholders, much of which actually can't be done without shareholder approval if you're a Delaware entity, but nonetheless, if you do that, it used to be the prior policy said there would be an adverse recommendation just at the next annual meeting, something you took a one-time hit. That's no longer the case. Now it is a continual, it's like they will continue with that negative recommendation until you either unwind the action or it's ratified by shareholders. So it's not just a one-year hit anymore. It is a continual beatdown. Glass-Lewis, overboarding. It's very similar to ISS, except that with an exec starting in 2017, you can only serve on 1 other public company board. So ISS, they give you 2. Besides your own, Glass-Lewis beginning in 2017, just 1. Again, like ISS, 2016 is a transition year, so you'll get some cautionary language, but unless you're currently exceeding their limitations, director overboarding will not result in a negative reaction. And there's a few others, but I have to say nothing overwhelmingly interesting.
So I promised that I would leave some time at the end for questions, and we do have a couple of minutes. Are there any questions? Raise your hand, scream, do what you want. I'm seeing nothing, so I think we're going to call it a day. Thank you very much.